It's Indiana in the Morning, presented by First Commonwealth Bank, and it's time for Martial Law. Now, this program is intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each problem depends on its individual facts, and different jurisdictions have different laws and regulations. And because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. I know one of those. He's sitting across the microphone from me. He's Marshall Chriswell. Good morning.
Good morning.
Now, I wasn't here the last time you were here, but I understand they were talking, you and Chuck were talking about, this is National Make a Will Month?
Yeah, that's right.
For a couple more days, then after that, you're not allowed to make a will. No, it calls attention to the fact that people need to make a will, and certainly there are many, many considerations. So that being the case, let's go the opposite direction. What happens if you don't? What are the things that happen to your property if you pass away and you have not made a will?
Well, if you haven't made a will and you find yourself deceased, then you the distribution of your assets and the administration of your estate, it does what Pennsylvania law says it has to do. Mm-hmm. Essentially, you are ceding that responsibility of making those decisions to the politicians in the state legislature. Mm-hmm. And so Pennsylvania law has provisions for intestate estates, and that's what we call it. If you die without a will, it's an intestate estate. And so there are very specific provisions on how your assets are going to be distributed. So a lot of times I talk to someone and they say, well, I don't need a will. It's just me and my wife and our two boys, and I want everything to go to them anyway. So then I'm sure that's what'll happen. Well, yeah, that's kind of right. But if you pass away and you leave some assets behind, and you have a wife and two children, most people, when we do estate planning, say, well, I'd want my wife to have everything or most everything, and then, when the second one of us passes away, that's when the kids would inherit. But unfortunately, that's not what Pennsylvania law says. Oh. Pennsylvania law requires, and it depends on the size of the estate, but it requires the surviving spouse and the children to split all the assets. Mm. So what does that mean? In an estate where the largest asset is the marital home, and for some reason, if it's, and a lot of times the marital home is in joint names, which can help, but other times it's not owned in joint names. But what this leads to is assets that the surviving spouse would otherwise have the enjoyment, use, access to, have to be sold so that they can be split with the children. And sometimes the children do what you may consider the right thing and say, well, we're not going to take our inheritance. Sure. But sometimes they don't.
Yeah. Yeah, and especially there are so many different family situations now.
Yeah.
Where there are parents who are estranged from children, and there can be any number of different issues that occur. Maybe a child is married, and the parent is not aware of just how much influence that spouse has over that child. And I can see where there would be many, many situations where people would find themselves, in a very difficult situation, thinking, okay, my husband passed away, but I'm good, I'm still here, and I'm in the house, and everything that was his is mine, and we're good. But that's not the case.
That's not always the case. And, what if, unfortunately, with the opioid endemic that we're dealing with, mm-hmm. What if a child has a drug addiction that you know or don't know about? And how can that affect? Or, another situation that it's really important to have a will is if you have, I guess, what you call a blended family. So you have folks that married or on maybe their second marriage or relationship, and one or both have children from previous relationships. Mm-hmm. That's another sticky situation that the law doesn't really do a good job of providing for. So, or long-time longtime partners, folks that have been together, lived together. It used to be back before, I think it was 93 when common law marriage was abolished. If you lived together and held yourself out as husband and wife for a period of time, then you could become spouses and have inheritance rights. Now I've dealt with estates where people are together for 20 years. And they don't have any, they don't have an estate plan in place, and they don't have any inheritance rights from the other. They're basically, as far as the law is concerned, they're strangers.
Yeah.
So that what kind of havoc does that wreak on the surviving partner?
All right. So all those considerations and probably many more would really strongly urge people to get in touch with their attorney and to make sure that they're getting that ball rolling on getting a will written.
Yeah, absolutely. And that consultation, and even though, like we said, National Make a Will Month is coming to a close, I always offer free consultations for estate plans because I think it's just that important to get somebody in the door at the table and to have the discussion.
All right. Someone who hasn't had that discussion at all, even among their own family, what do they need to bring to that initial consultation?
Nothing. I make it as easy as possible. You don't need to bring bank statements or insurance policies or really anything. That initial consultation is for me to get general information about your family structure, what your goals are as far as the estate plan is concerned, what the general assets and liabilities are, if you passed away today, what would that estate look like, and how would you want it distributed? So it's a general conversation, and then from there, if I need more specifics, then I can ask you to get this document or that. But I like to make that initial consultation as easy as possible because it's the hardest step. It's the thing that people don't want to do. They don't want to think about their own mortality, and that is a very concrete thing to call and make an appointment and show up at an attorney's office to talk about that. So I want to make that as easy as possible for people.
It's a genuine fear that people have, not only of what you said, passing away, but sometimes people are just very frightened to get into a situation where they don't know their way around a particular system, in this case the legal system. So they're going to get words thrown at them that they're not aware of what they mean, and they just want to avoid that uncomfortable situation. I'm sure you reach out and you make sure that it's I don't want to say a light-hearted conversation, but it's not going to be a heavy thing that is going to require them to really buckle down. And
yeah, absolutely. I do try to make that as easy as possible. I understand that not everybody has spent half of their adult life in school and learning, and know the vocabulary and those kinds of things. I do try to make that as easy as possible and really have a conversation that whenever you get up from that table and you leave, you understand what the plan is that I'm recommending that you put in place.
One of those terms that people will hear very early in the process is executor.
Yeah.
Which sounds very intimidating to people. Explain the concept and some of the considerations you have to make when you are thinking about who's going to be the executor of your estate.
Sure. Another word for executor is manager. This person is, so whenever I draft a will, I've got to include an appointment of an executor. So that's a decision that my client is going to make about who is going to manage their assets when they're gone, who's going to manage their estate when they're gone. And that person, their job is to make sure that the assets of the estate are identified and safeguarded, to pay any taxes, debts, final expenses, funeral bills, medical bills, those kinds of things, all of that, and that the estate is administered according to Pennsylvania law, and that distributions are made according to what the will or the trust says. Mm-hmm. And so it's very simple. They're the manager of the estate. The considerations are you want somebody that would make a good manager. You want somebody that can handle some simple paperwork, can meet with an attorney and talk over the options and balance a checkbook. And also, to an extent, someone that can would either be good at mediating disputes between their siblings or other, the beneficiaries, or somebody that can kind of lay down the law and say, okay, this is the way it's going to be, because in the end, the executor has the final say as to what happens unless a court gets involved.
You'd have to be pretty well acquainted with the family dynamic there,
Yeah,
in order
yeah.
to make that decision. Here's something that comes up to my mind, because I've heard of this and I don't know if it's actually the case. You as an attorney would know this. Somebody who passes away and has safe deposit box in a bank, and maybe it was he and his wife, and she's now gone, and he's the only one, and so he passes away. That safe deposit sitting there in the bank, he's the only one authorized to open it.
If there are no other owners on the safe deposit box, if it's owned solely by the decedent, the person who passed away, then it can be difficult to get into the safe deposit box in a timely manner. So people ask me, should I put my will or my powers of attorney or my trust documents, those kinds of things in a safe deposit box? My answer is always no, because it can be difficult, although the law says that somebody can go in there and get it as long as there's someone from the bank to watch over their shoulder and take an inventory or whatever they're going to do. It can be difficult depending on the bank and the situation. So that I don't recommend. But otherwise, that safe deposit box, the stuff that's in there, and a lot of times there's valuable things in safe deposit boxes. Of course, that is going to be part of the estate, just like a bank account or a piece of real estate, and those things could be. They're taxable and all those kinds of things.
And when you get right down to really fashioning and crafting that will, that's going to be part of your discussion with them. Okay, what's the best way when I pass away? Not only do I have a will in place, but what are going to be the mechanics of after I'm gone? My executor is going to come in and going to need to find things, and so what am I going to have where?
Absolutely. Where to keep the documents, if you're going to make copies, what to do with copies, make sure that they're kept safe and all those things. Also, I do just a general discussion with every client about things that, that I think make it a lot easier on your loved ones whenever you're gone. What kinds of, that you should have a file. And a lot of people have this file that's called like When I Die. And you should have that. And we talk about what should be in there so that there's not a lot of confusion and stress in addition to the stress of losing a mom or dad.
And make sure somebody knows where that is.
Yeah, absolutely. And that would be your executors or your agents or your trustees.
Yeah. He's Marshall Chriswell. As I always tell my church congregation, the death rate is 1 per person, so this is what we need to get a handle on here, each and every one of us. We're just about out of time for this segment, but for those who want to set up that initial consultation with you or have any other legal matter they would wish to discuss with you, what's the procedure?
Stop in the office in the Atrium Building, downtown Indiana. Give me a call at 465-5826 or find me online at westernpalawyer.com.
He's Marshall Chriswell. The segment is called Marshall Law, and it's Indiana in the Morning, presented by First Commonwealth Bank here on WCCS AM 1160.